My freshman year of college, I spent a lot of time outside my dorm room, which, given the size of the room that I shared with two other women, it was objectively the correct choice. My primary motivation for avoiding the room that my parents lovingly and generously paid for was a roommate that was very friendly with members of the opposite sex. I didn't want to sit in awkward tension while my roommate waited for me to leave or, worse, fall asleep, so I made myself as scarce as possible. Preparing this episode script and reading about roommates in tight quarters aboard a ship made me profoundly thankful that, although my roommate made it difficult to spend time in my room, at least the activities she engaged in were consensual. This is Conduct and Becoming. I'm Erin, and I'm your host. Seaman Coda Harpole served aboard the U.S. Coast Guard Polar Star alongside a talented group of his peers. In late February 2014, the ship made a port call in Tahiti, a far cry from the chilly Alaskan port the last time we touched base with the Coast Guard in episode 30, the U.S. vs. Tucker. While on port call in Paradise, Harpole spent the evening of February 28th drinking and socializing. He said that while they were out drinking, a storekeeper third class that I'll call Gina was very flirty with him. At some point, he asserts he gave Gina his backpack to take back to the ship. When Harpole was done painting the town red, he returned to the ship and wove his way to Gina's bunk. He says he knocked on the door to her berth and that Gina answered, but he claimed he did not remember anything past that point. Gina's roommates, however, were able to fill in some of the details of Harpole's arrival. Let's call the first roommate Allison. Allison awoke with a start when Harpole opened the curtain to her bunk, asking where he could find Gina and mumbling something about a backpack. She gestured towards Gina's bunk and watched as Harpole shook Gina awake to talk with her. Then Allison fell back asleep. As you've undoubtedly realized, Allison's version of events is already vastly different from Harpole's. Gina was fast asleep when Harpole entered the berth. She didn't get up and answer his knock on the door. In fact, by Allison's description, Harpole entered the room without anyone's permission. Allison later woke to hear the sounds of sexual activity, which she believed to be consensual. The other roommate, who we'll call Blair, similarly awoke to the swaying of her bunk bed and sounds of what she also believed to be consensual sex. Later, Gina described having a number of alcoholic beverages throughout the day and evening of February 28th. When she awoke on the morning of March 1st, she discovered she was nude. At first, Gina believed that she'd had sex with an ex-boyfriend. Then she began to recall flashes of her night. One of Harpole's face while he was on top of her, one of Harpole shushing her, and one of Harpole climbing off of her and leaving. Allison and Blair, believing the sex was consensual, confronted Gina, telling her that what happened that night was unacceptable. Gina told her roommates that she didn't know how it happened, how she and Harpole ended up having sex, that she didn't remember what happened to her that night. Realizing their mistake and their misinterpretation, they encouraged Gina to report the incident and accompanied her in making an unrestricted report to an officer. A restricted report is a report of sexual assault that is made confidentially in order to receive counseling, medical care, and other assistance but without triggering an official investigation. In contrast, an unrestricted report must be disclosed to the command, and the command must inform law enforcement. After Gina made her report about the incident, command transferred her ashore for transportation back to their home station stateside. Gina had opposed the transfer, and that transfer stood out to me because I've always understood that unless a victim requests it, you don't move the victim of sexual harassment and assault, you move the perpetrator. Because otherwise it starts to look like you're penalizing somebody for reporting a crime. But I acknowledge that it is entirely possible that I'm looking at this through a biased lens because of a much more questionable decision command made. Harpole was on the Special C detail that transferred Gina ashore so that she could be sent home. And in the days that followed that transfer, Harpole approached a friend of his that we'll call Scott. First, he asked if he and Scott could talk somewhere more private. Once they reached the fantail, Harpole explained to Scott that really, he felt like Gina had assaulted him. So Scott recommended approaching a victim advocate stationed aboard the ship. Harpole chose a particular victim's advocate, Holly, because he felt the most comfortable with her. He worked in the administration office under her supervision. So on or around March 3rd, Harpole woke Holly up with a knock on her door. Seems to be a bit of a habit. Holly inquired why Harpole wanted to talk with her, and Harpole clarified that he wanted to speak with her in her victim's advocate role. She didn't think that Harpole came to discuss what happened with Gina, an incident she already knew about. So Holly led Harpole to a lounge where they could speak privately, a space that wasn't also where she lived. There, Holly again asked what he needed to talk to her about and whether he was comfortable with Scott staying there. Harpole told her that he wanted Scott to sit in with him because Scott already knew everything and he wanted him there for support. Holly explained that if Scott was there, any report he made would be unrestricted and she would have to inform the command. And as we already know, the command would have to inform law enforcement. Harpole indicated he understood. Harpole revealed that he had previously been sexually assaulted when he was a child, and he knew what that felt like. So, based on that previous experience, he reportedly believed Gina had assaulted him on February 28th. During the conversation, Holly relied on her victim's advocate training and mostly allowed Harpole to share his story. She interrupted once to ask what Harpole was doing in the women's birthing area, but waved the question off before Harpole could answer. Scott attested that Harpole described Gina grabbing his hands and using them to touch herself. But that's a little confusing because it's not clear how Harpole would feel that the following day. Nor is it clear how that lines up with Harpole's story that he doesn't remember anything past knocking on Gina's door. Perhaps it was just a vibes-based report. Bringing a support person in, a support person with whom you share no separate basis for privilege, can be a risky decision when it comes to making statements you'd like to keep confidential and privileged. While I'm not sure about the details of reports made to victims' advocates, bringing someone like that to an attorney meeting waives privilege. So there are some situations where texting your personal lawyer and your wife about a legal matter you're involved in might be privileged communications, because you hold attorney-client privilege with your lawyer and spousal privilege with your wife. But texting a personal attorney turned new Navy JAG, your wife, and your brother about war plans, for instance, would not be. Harpole described the conversation with Holly as weird, like she was probing for something he wasn't saying. He said he just wanted her to listen to what he had to say and seemed frustrated that Holly had what he perceived to be specific questions she wanted to ask. It's not clear if he alleged she actually asked those questions. As I mentioned briefly, When Harpole approached Holly, she'd already been made aware of Gina's side of the story. In fact, Holly prepared those orders to transport Gina back to their home station. Consistent with her warning or disclosure to Harpole, Holly went to a superior in her command and disclosed his report. Ultimately, the government charged Harpole with committing a sexual act upon Gina when she was incapable of consenting to the act due to impairment by an intoxicant. His fellow coasties found him guilty of 1 specification of making a false official statement, 2 specifications of sexual assault, and 1 specification of housebreaking, for entering that room without permission from any of the residents. It's worth noting that Harpole was convicted of 2 specifications of sexual assault for the same incident. One of those specifications was conditionally dismissed as an unreasonable multiplication of charges. Harpole received a sentence of confinement for 7 years, reduction from E3 to E1, and a dishonorable discharge. Before we flip to the legal beagle section, I want to toss another case at you. Private First Class Danielle Deremer kicked off her Marine Corps career by standing on the yellow boot prints at Marine Corps Recruit Depot, Paris Island. In November 2021, while still in boot camp, Deremer approached an NCIS Special Agent Peters, to report that she had been sexually harassed and abused at the hands of another female PFC. She gathered Special Agent Peters, her uniformed victim advocate, and her victim's legal counsel, and described a number of instances of unwanted sexual touching. Deremer asserted that the other PFC touched her breasts and buttocks without her consent and forced her to reciprocate. Following that first interview, Special Agent Peters explained that he might reach out again, but that was unlikely. He concluded that if he needed to reach out, he'd contact her through her victim's legal counsel. Then, Special Agent Peters got to work interviewing the suspect Deremer named, along with 7 other witnesses. At the close of his investigation, he determined on his own that the allegations Deremer made were false. In December 2021, Special Agent Peters closed the investigation into the report Deremer made and opened a new one, this time naming Deremer as the subject. 2 months later, in February 2022, Special Agent Peters brought Deremer back in for another conversation. The agent hadn't contacted Deremer's victim's legal counsel to set up the meeting, even though she was still represented. To Deremer, he explained that if the case agent develops probable cause to believe that a reporting victim lied, NCIS policy dictated that the agent close the case and open a perjury case for the reporting victim. He also said that it was policy that when that happened, the subject was no longer treated as a victim. When pressed on it, though, he couldn't identify an actual written policy that directed him to do this. Then, Special Agent Peters provided Deremer with an Article 31B, 31 Bravo, advisement of her rights, kind of like her Miranda rights, which she then waived. During their conversation, Deremer made incriminating statements, and the government took statements made in that second interview and charged Deremer with making a false official statement and malingering. Article 83 prohibits service members from feigning illness, disablement, mental lapse, or mental derangement, or intentionally inflicting self-injury in order to willfully avoid work, duty, or service. It's not widely discussed, but from what I can put together, the charge was based on faking an injury necessitating a wheelchair in order to avoid her responsibilities at boot camp. Deremer was convicted of 1 specification of making a false official statement and 1 specification of malingering. She was sentenced to reduction from E2 to E1 and a bad conduct discharge. I wanted to sneak this second case in here for a couple of reasons. First, I felt the opinion is a really nice contrast to the 2016 Coast Guard Court of Criminal Appeals opinion in Harpole's case. The Deremer court took on really challenging areas of law and made the opinions they filed accessible. Second, and perhaps more relevantly up here before the legal beagle break, I rather frequently run into comments on other social media pages implying that women who serve in the military and who report their assaults are lying. The estimated false report rate is somewhere between 2 and 5%, and I thought this case might reassure, well, mostly men, that the phenomenon is rare and can result in prosecution. You'll find in the show notes links to 4 separate opinions for Harpole. That's 2 from the Coast Guard Court of Criminal Appeals and 2 from the Court of Appeals for the Armed Forces. In his first appeal to the CGCCA, Harpole raised 9 separate assignments of error and, in an appendix, personally asserted 7 other issues with his case, mostly centered on the procedures implicated in the investigation of his report, the way he was treated following his report of sexual assault, and the reportedly triggering and re-traumatizing nature of his court-martial. His appeals centered around the court's decision to admit Holly's testimony regarding his statements to her in early March, when he reported his alleged sexual assault. Harpole challenged her testimony, asserting that that conversation was privileged. Or, in the alternative, that Holly functionally served as an investigator, and that he made those statements to her, to an investigator, absent a 31 Bravo warning. He also claimed that he received ineffective assistance because his counsel failed to keep those statements out. The CGCCA denied him any relief, and CAF took a more nuanced approach to the analysis. They really drilled down into the reasons Scott's presence as a third party negated any confidentiality, highlighting that he held no discernible special relationship with Harpole, and perhaps more importantly, was not there to facilitate the victim's advocate in providing advice or assistance. To draw a comparison to the law, something I'm obviously more familiar with, it's not like Harpole met with an attorney and the attorney's paralegal was in the room, a third party who is not an attorney but present to facilitate the lawyer's provision of legal advice. CAF determined that the only real question that remained with respect to Harpole's ineffective assistance of counsel claim revolved around that issue of whether counsel could have succeeded in suppressing Holly's testimony on the theory that Holly functionally served as an investigator and should have provided a 31 Bravo advisement to Harpole. Those warnings are required when a person who is subject to the Uniform Code of Military Justice interrogates or requests a statement from an accused or person suspected of an offense, and the statements are about the offense for which the person is a suspect. Holly was subject to the UCMJ, so that factor is quickly disposed of. Holly was also aware of Gina's report, so she knew Harpole to be a suspect, another factor down. That left the million-dollar question, the question of whether Holly interrogated Harpole or requested his statement about the assault on Gina. But the record before CAF at that point showed only that Holly asked 2 questions. First, she inquired what was going on, and second, whether it was okay that Scott was there. CAF reasoned that Holly's questions revealed that she suspected Harpole was approaching her in her role as victim advocate. Asking what was going on demonstrated that she sought to elicit information from him. They then looked at the result, to Holly's report to the command about Harpole's statements, and concluded that the facts and the records before them raised a colorable claim that Holly engaged in the conversation with Harpole both as a victim advocate and as a person participating in an investigation. So with that backdrop, CAF returned the case to the military judge to conduct additional fact-finding around the issue of whether defense counsel's assistance was ineffective. They tasked the judge with determining whether legal and tactical considerations were involved in defense counsel's decision not to file a motion to suppress the statements Harpole made to Holly on 31 Bravo grounds. Whether that decision was a reasonable strategic decision, whether there was a reasonable probability that such a motion to suppress would have succeeded, and whether there was a reasonable probability that the members' findings would have been different if Holly's testimony had been suppressed. They only really get to that final consideration if the answers to the other questions lead them there. The questions CAF sent back to the military judge required eliciting additional testimony of Holly, but also of the defense counsel that handled the case. The last thing any attorney wants to do is be a witness in one of their cases. But on remand, the military judge found that a motion to suppress under 31 Bravo would not have succeeded. The CGCCA agreed and concluded Harpole's claim of ineffective assistance of counsel failed. The opinion is a robust analysis of IAC and is a good read if you're intrigued by defense decision-making. CAF took a final pass at the case in 2021 and similarly concluded that Holly was not required to give Harpole his 31 Bravo rights advisement because the limited questions she asked were not made in an interrogating manner and weren't designed to elicit incriminating statements. Because she was not required to make that advisement, the claim that Harpole received ineffective assistance of counsel was moot. We'll turn briefly to Deremer's appeal before I wrap up. The NMCCA was tasked with evaluating whether the military judge abused their discretion when they allowed in the statements Deremer made in her second interview. Deremer is a great foil for the Harpole decision, where Harpole did not receive a 31 Bravo advisement from someone acting in their victim advocate role. Deremer, a reporting victim, did receive a 31 Bravo advisement from a law enforcement official. Neither party had an attorney with them while they made the statements that sank them. The rub in Deremer's case, as best I can tell, is that the vast bulk of the evidence supporting the conviction for making false official statements came from that second NCIS interview. Sure, there were 8 witnesses who contradicted Deremer's report, but it's unclear if that would have been enough to sustain the conviction for making a false official statement. In a fractured opinion with 2 separate opinions filed concurring in part and dissenting in part, the NMCCA concluded that the statements Deremer made in her second NCIS interview should not have been admitted. Alleged victims of sexual assault are entitled to legal counsel through every phase of the military justice proceeding, and the NMCCA held that Deremer was still entitled to her victim's legal counsel in that second interview, the interview where NCIS labeled her a suspect. And I think that's where I would tend to land. In every area of the law that I have practiced within, if a party is represented, you route your communication through an attorney. Even though Special Agent Peters unilaterally determined that Deremer was not a victim, she still had victim's legal counsel detailed to her for the statements she had previously made, the statement Peters challenged her on in her second interview. And I think that puts us in a different spot than Harpole. If Harpole invoked his right to counsel at his first meeting with an actual investigator, he would have been detailed counsel, and there's no question that a second interview done without counsel would violate his rights. I dislike any argument that Deremer waived her 31 Bravo rights so her statements were voluntary, because I generally dislike anything that chips away at a suspect's right to counsel. Once you invoke and you have an attorney, that's the ballgame. And I think it has to be said. It feels too mushy to say that law enforcement gets to decide whether or not someone is a victim, to bring them in under the pretense of following up on their report, then labeling them a suspect and interrogating them about a crime without including their attorney. The disagreement among the NMCCA opinions was over the remedy following this violation. The majority opinion held that the remedy was rejecting those statements made in the second interview. But the disagreement among the judges over whether that was the appropriate remedy makes this a good candidate for CAF to address. Thank you for listening. If you enjoyed today's episode, please be sure to rate the podcast wherever you listen. I invite you to submit case suggestions and feedback to conductunbecomingpod@gmail.com or on conductunbecomingpod.com. Join me next time when we return to the issue of panel selection. Until then, take care. Conduct Unbecoming is a podcast where I get to talk about interesting crimes and cases that involve U.S. military service members. I research, write, and produce the podcast myself. The opinions expressed are my own, and perhaps it's obvious. Conduct Unbecoming is not approved, authorized, or endorsed by the Department of Defense.